Good morning, everybody. My name is Gary Wickert. I'm one of the partners here at Mathieson, Wickert & Lair. And as you know, we handle subrogation for a lot of you. I saw the attendee list. Some of you we haven't had the pleasure of working for, but hopefully you've heard of us. I'm going to be presenting today on this topic, which workers' compensation benefits can be subrogated, with the assistance of one of our more senior paralegals, Emily Bates. She's one of our medical paralegals who has the unenviable task over the years of having to scrub work comp liens and explain their contents to angry trial lawyers who think they shouldn't have to repay comp liens. But that's what we do here for a living, and this subject is actually a very unique subject. I don't think it's been presented anywhere. We will talk a little bit later about some of the handouts that you've been given and how you can use those. But we are still in the early pioneer days of workers' compensation subrogation, if you can believe that. What that means is that there are not answers to a lot of questions you may have. In certain states, can you subrogate for UIM benefits? Can you subrogate for PIP benefits? Can you do you owe attorney's fees? Is there equitable reduction or made whole applicable? Which states' laws apply? These questions, which come up throughout the handling of work comp subrogation claims and work comp claims in general, often don't have an answer because that issue has not been brought up to the commission, or it hasn't been the subject of a lawsuit, which then goes up on appeal. And there's a written opinion on it, so there's a lot of criteria and boxes that have to be checked before we get answers to questions. So we're still in the early days, and with regard to which work comp benefits can be subrogated, case management costs, medical bill audit fees, rehabilitation benefits, utilization review costs, there's not a lot of answers. Emily is going to be going into those. Emily, are you with us this morning? Good morning.
Good morning.
Emily is going to be going through what these items are, why they're in the lien log that we often have to provide to all the parties. But for this presentation, think of it as a movie that really captured your interest and you couldn't wait to see it, but after you saw it, you were let down, or a movie that started out incredibly well, but later trailed off into sort of mediocrity. Hancock with Will Smith, a movie I enjoy, is sort of like that, or Downsizing with Matt Damon. These are great movies, and then you kind of go, wait, where's it going? And it kind of fizzles off. This webinar is going to have some of those characteristics because we aren't going to have black and white answers for you on can medical bill audit fees be subrogated successfully in Idaho. Idaho hasn't answered that question. Most states haven't answered that question. And as you'll see in this webinar, most states haven't answered the questions as to what can legally and ethically and successfully be subrogated out of your work comp lien. But we are going to, in this webinar, provide you with answers where it is available and also give you the arguments that you need to craft a good case in favor of recovering some of these things. So you won't be given many answers, but we will provide you with the tools to defend yourself when trial lawyers cry foul because you include an IME charge or a nurse case management fee in your work comp lien. Sadly, there are risks involved with including things in your lien which do not constitute benefits or misrepresenting the nature of certain payments. We'll talk about that and give a couple examples. But we hope that this webinar will guide you through the minefield which has become workers' compensation third-party subrogation. So with that, let's get started. I'm going to talk just a little bit about the history of work comp subro. Oh, not again. And the reason I do that is because it is very important for us to understand that this is not like auto subrogation. Somebody buys a car and they go get an insurance contract and they want a policy to protect their car, or you're buying a homeowner's policy where you are liable as an auto owner. You're liable only if you're negligent. Workers' compensation is something quite different. The employer is liable even when he's not negligent. or it is not negligent. And so I want to stress the fact that we should be protecting our right to recover these work comp payments and our work comp liens, because the grand societal bargain, which is workers' compensation, sort of says, hey, employer, you're going to have to pay all these benefits, even if you're not at fault, but we're going to protect you by making sure that the employee can't sue you, and even that's being eroded in a lot of states, but that's the subject of another webinar. And we're going to allow you to recover this money back so your employer has a lower risk modifier, and so that the cost of work comp, which is a major cost of doing business across the country, is lowered. So just a quick history lesson. Ancient history, work comp goes all the way back to 2000 BC with in the Fertile Crescent with the Nippur Tablet, pirates back in the 1600s. There's a great book called Black Flags, Blue Water by an author named Eric Dolan, and he talks about the Buccaneers back in 1630, and before they were demonized and relegated to the ranks of outlaws. If you know your history, pirates were actually partners with governments. They shared their plundered spoils with governors of early U.S. colonies, who would in turn provide them with safe harbor. And these pirates realized that human capital, the pirates, the workers, the sailors on their ships were vital to the success of their endeavors. And so they actually developed the first early form of workers' compensation. Captain Henry Morgan of Rum Company fame in the mid-1600s had a ship constitution that provided for the recompense, quote unquote, recompense and reward. Each one ought to have that either is wounded or maimed in his body, suffering the loss of any limb in their voyage. For loss of an eye, there was 100 pieces of 8. For loss of a left arm, 500 pieces of 8. For loss of a right arm, which is normally the sword arm, 600 pieces of 8. So pirates had an early form of workers' compensation. Later in the 1800s, in Prussia, Chancellor Otto von Bismarck had a very active Marxist and socialist movement, and protection for workers was at the top of their agenda. He had an early form of workers' compensation. This led to, in the late 1800s and early 1900s, with the Industrial Revolution, public sentiment here in the U.S. for organized workers' movements began to grow. You may remember Upton Sinclair's The Jungle, detailing the horrors of a Lithuanian immigrant working in a Chicago slaughterhouse. Well, that book was horribly written. The Time magazine critic once said, of the many millions of words Sinclair wrote, few were in the right order, but it was the right book at the right time. So work comp in the dawn of the 20th century came about because employers were being sued by their employees. Now, it was hard to win, but the employees had no choice, so employers were always defending these cases. So in 1911, Wisconsin became the first state to pass a workers' compensation law. At that time, we had in Milwaukee, we had a socialist mayor, and there was a socialist member of Congress, and so there was a big populist movement, and workers' compensation has its roots in that. Protecting the worker, the grand societal bargain is that we are going to pass this liability on to the employer. It's not fair, but that's the system we have. So we have to fight for the employer because this is a huge cost to them. Now, 50-state overview, this webinar isn't about that, but I'm just going to really quickly mention that states vary. Understanding which states are good for work comp and subrogation and which are not really can play a role in which state's benefits you provide to begin with, because often you have a choice. So the 10 best states are Wisconsin, which is by far the best state for work comp subrogation for a lot of reasons we don't have time to get into. Alabama, Delaware, Wyoming, Iowa, Hawaii, Maryland, Rhode Island, and Texas. Texas used to be number one, but back in the early 2000s, they decided that employer negligence should play a role. The 10 worst states, absolute worst is Georgia. We all know that. We have a philosophy and a strategy for subrogating in Georgia, but even then, it's difficult, and to get 100% of your lien back is very tough in Georgia. Florida also. Illinois, where the employer can be brought in, Kentucky, Arkansas, Massachusetts, Louisiana, Michigan, California, New Mexico wind up the worst 10. Now, why does this matter? Historically, lien documentation for us has been, well, you get a log, a payment log, and you send it to plaintiff's counsel or defense counsel or to the third-party carrier, and it says, we've paid all these benefits. Sometimes it's descriptive with a payee, date of service provided, amount. Sometimes it even includes the billed amount versus the paid amount, which is now important because a lot of states are not allowing you to recover the reasonable medical cost. They're not allowing the employee to recover it, but only the paid amount. So our lien documentation now becomes very valuable. But historically, we just sort of sent it and we didn't think much about it, not knowing that, hey, there's some things in there that maybe don't constitute a benefit. So why does it matter? Let's go down to Tyler, Texas in 2019. In the In Re Old Republic risk management case, this was a lawsuit in which the plaintiff's attorney sued Old Republic for a fraudulent lien, insurance code violations, fraud. They were claiming that Old Republic fraudulently inflated its lien by representing that certain contract payments made to a catastrophic care management company were medical payments for the benefit of the employee. And despite knowing that the payments were not medical payments. So this led to the idea that, yeah, a work comp carrier can be sued for fraud if they are not upfront and honest with regard to exactly what the benefits are that are being subrogated. So it not only becomes a good practice if you start including a lot of things in your lien that do not constitute benefits for the treatment of the employee or his or her recuperation and well-being, you could not only be buying yourself a lot of time wasted and dickering with plaintiff's counsel, but you also could open the company up to some liability. And we're seeing a lot more of that lately, and that's something we don't want. So it's important that the work comp lien fully document everything and that we're very upfront about it all. Now, another reason why it's important is because work comp costs in general, some of the things we're going to be talking about here today, are significant. As you can see, the cost to employers for workers' compensation costs $2.58 per $100 of payroll. This underscores the importance of subrogation. They need to get this money back. Otherwise, their experience mod goes up, as does their premiums. So we actually owe a duty to our insureds to aggressively subrogate, but subrogate in good faith. The cost to carriers, this is a $17 billion line of insurance. Medical costs represent 36% of these claims paid. Indemnity represents 28%. And the cost to run the system, the overhead, is 36%. So that's lost adjustment expenses, commissions, general expenses, taxes. So for every dollar spent, only $64 goes to the worker. So in the line between benefits, as we'll see, and overhead can be murky. And we're going to try and make some clarity about that. But before we do, let's get an understanding of the different payments and expenditures that you will find in the adjusting claim. And this is where the expertise of Emily comes in. So, Emily, do you want to take over here?
Yeah, thanks, Gary. As Gary mentioned, parties to an action like to find reasons not to pay portions of the lien, and we're always asked for updated payment listings from parties, what billing codes on payment listings mean, what specific line items are if they don't recognize it, which actually happens a lot when someone doesn't understand what a medical provider is versus a billing provider. And when we get these requests for the updated payment listings, we'll request those from the client or the workers' comp insurer. When those come in, we'll review for some of the items mentioned above, but more importantly, the potential unrecoverable items to present our quote-unquote clean lien to the parties. And this is to clear up any confusion, but to also make sure we're not requesting items that might not be permitted to be recouped under the law, which of course, as Gary said, varies state by state. Some of the pay codes we see, they're for the classes of the work comp insurer assigns payments to for the internal reporting classification. But this also helps us break down the payment listings we receive, and it'll streamline the process of distinguishing between recoverable and unrecoverable items. It just helps us clarify what each payment is for instead of showing just a doctor's name or a service. And these are usually broken down by simply medical, indemnity, and expense, but then is also further broken down into items like prescriptions or physician fees or case management, and then plenty of other pay codes. And one item on these listings that's of debate is the nurse case management fees, and that is the coordination and organization of medical care in order to expedite the employee's return to work. And these nurse case managers are actually nurses that are responsible for planning and providing efficient and high quality healthcare, which involves assessing new patients, updated healthcare plans as needed. They'll educate families about healthcare options and make clinical decisions. They'll document and submit medical records and also report back to the insurer. And they work as a great hub for information on employees' treatment. They'll make and sometimes attend the appointments and prepare reports for our insurers, which is also shared with Work Comp Defense Counsel. And that can help with disputing unnecessary treatment, which keeps costs down. And Gary will talk a little bit more about that, I think. But medical case management is also a questionable line item, and that would be the payment for the catastrophic and complex outcome-based contractors and vendors. The line items we see on payment listings are usually labeled case management or medical case management. And most of the time they're actually nurse case management, but we always have to go back to the adjuster and confirm that it's not any administrative cost. If the payment listings could have a category for nurse case management, I know that would streamline a lot of our review and save some emails. Bill reviews examine medical provider bills and then disallows or reduces charges in excess of either the state fee schedule or reimbursement amounts or the network contracted arrangements. And I actually saw there's an estimate out there that says up to 80% of medical bills contain errors. So this is important, but a lot of states don't see it as a benefit to the employee. And the main benefit of the bill review maximizes savings by lowering claim costs. Those are usually always on payment listings, so we keep an eye on that. And then effective April 1st of this year, the California Division of Workers' Compensation has their new medical legal fee schedule, which will increase the cost of medical legal evaluations and impact contested claims. These charges will apply to primary treating physicians as well as QMEs and AMEs, and as a result, we'll see an increase in the medical liens. And on to our poll question. Which of the following groups practiced an early form of workers' compensation? Led Zeppelin, Pirates, Flat Earthers, or Scientologists? All right, Gary led with a great introduction to this, and the answer is Pirates. Some other items that are on payment listings, you'll see IME charges. An independent medical exam or an IME is a medical evaluation performed by a medical professional or expert on the employee to evaluate their course of prior treatment and current condition. And an insurer might request this to determine the compensability, extent of disability, the necessity of any treatment, and type of treatment. and also to evaluate whether there's any permanent disability or loss of earning capacity. And this is completed by a doctor or an expert that hasn't treated the employee. An insurer might request it because it might disagree with a decision by one of the treating doctors about the course and medical treatment, especially if surgery or another expensive procedure is recommended, or when making a decision about permanent disability. A judge could also order this if they need to resolve a disputed issue. For rehab, vocational rehab is a workers' comp benefit that provides a disabled employee assistance getting back into the workforce, and this might include job training or career counseling, and then assistance in finding maybe different employment. For medical rehab, benefits may pay for medical and therapeutic care, which might be physical therapy, and that's to help with the employee to recover from the injury. Utilization review is the review of actual medical services provided to the employee just to determine if it's a necessity and appropriate for the injury. As far as recovery goes, this of course depends on state laws and whether allocated costs can be recovered. There's not a precedent. If there isn't a precedent on it, we might keep them in our payment listing and later argue that these help keep medical costs down, which would keep a lien to a minimum, but we just need to make sure there's room to make that argument, and we'll touch on that more later. A lot of third-party vendor charges we see are investigation fees, bill review fees, which we touched on above, and copy fees, which will be medical record requests or legal copying. And then workers' comp case attorney's fees. I know Gary's going to talk about this more too, but the employee's workers' comp attorney's fees in a lot of cases are recoverable, including costs for depositions since it's benefiting the employee. But on the other side of that, workers' comp defense counsel fees and costs usually aren't recoverable since it benefits the insurer. And for medical legal costs, as an example, California's definition of it is a cost or expense incurred by or on behalf of any party, the administrative director or the board, which those expenses might include x-rays, lab fees, diagnostic testing, medical reports, medical testimony, or interpreter's fees, and that's to prove or disprove a contested work comp claim. And we do have a chart on that talks about it, so we would direct you to that. Allocated expenses are for the general handling of a workers' comp claim, which could be nurse case management, vocational rehab, everything I talked about above, and some other items. And then unallocated expenses are the general overhead of an insurance company, which could be claims adjuster salaries and benefits. And then that's also discussed in our chart that Gary prepared. And on to Gary.
Thank you, Emily. This slide I hesitated and debated whether to include, but I thought it important to remind you that aside from some of the expenses that we're talking about, nurse case management costs and IME costs, there may be other types of payments that are made that are not allowed to be subrogated. It's a little different, and this goes from state to state. I'm using the example of New Jersey here with something called Section 20 payments in New Jersey. Section 20 provides for lump sum and full and final settlement of comp claims in contested cases, so where the carrier is not accepted liability. And some of those are not allowed to be subrogated or included in the lien, and they often are, so we look for those. Whereas Section 22, you've probably seen such liens many times, but you never heard of them in New Jersey as Section 22 settlements because nobody ever calls it that. They usually call it something like an OAS, an order approving settlements. But it's the section that regards typical resolution of comp claims. That is subrogatable. Whereas Section 20 is the section that deals with full and final resolution. It's a little bit out of the scope of the content of this webinar, but some states allow future amounts to be subrogated. Some give you a credit, some don't. It's just important to be fully informed. As many of you know, we have a book out there called Workers' Compensation Subrogation in all 50 states. I think we make like $1.10 or something on these books, and the publisher, which is Juris Publishing out of New York, puts a high price tag on them because they have to. We keep them updated, and there's a lot of work on them. But those books are useful if you have one that can go around the office that'll help you figure out whether something can or can't be subrogated. So which benefits or payments can be subrogated? This is literally the question that every claims professional and trial lawyer claims to know, but few fully understand, myself included. It's really amazing that in the year 2021, we can be sitting here with a workers' compensation system in our country that is 110 years old. Math is not too good. It's about 110 years old, and we still have issues that are unclear in most jurisdictions with regard to what can and can't be recovered. So we are left to craft our arguments. Generally, we're allowed to be reimbursed. Again, we are blessed with a republic, which is made up of 51 different jurisdictions, and reimbursement of benefits and compensation is really a state-run issue. You have to look at the statute. On our website, we have a lot of charts, as many of you know. One of the charts is workers' compensation subrogation. Goes through the law in all 50 states. It sets forth the statute, not the text of the statute because it's a chart, but you can pull that statute up, you can Google it, and it'll define for you exactly what the statute says. For example, in Texas, it says the carrier is allowed to be reimbursed for what? For benefits. All right, what's that? Including medical benefits that have been paid for have been paid for the compensable injury, and that's under the labor code. Well, that doesn't give you a lot of clues, does it? So sometimes you have to look to commission rulings, case rulings, common practice, or look at what some of the regulations talk about. And those are the things that are included in the chart, which is a handout that you have. In North Carolina, compensation, which is what you can recover, means the money allowance payable to an employee or to his dependents as provided for in this article, and includes future benefits provided therein. So again, not a lot of guidance, but this is generally what we are up against when somebody tries to make some noise because they're always trying to cut down our liens. Well, you can't recover that IME, or you can't recover that nurse case management fee. They have no better idea than you do as to whether you can or can't subrogate for that. They're just saying, well, that's an expense. That's an allocated expense. That's the cost of running the insurance company, just like the light bill. Well, not so fast. It really isn't. And so which benefits and payments can be recovered? A lot of times it comes down to what constitutes medical treatment. And there is shockingly few cases that have been litigated on this issue, but it's increasing. We'll go in just a moment. I'll give you an example of some of the questions that are posed to claims handlers in depositions when they're saying, well, what's this medical treatment for? Well, that was for nurse case management. Well, what does that mean? And so what they do is they try and drill down on exactly who is benefited by the medical treatment. Who has jurisdiction to answer these questions? It depends. In some cases, we have to bring this up before the Industrial Commission or the equivalent in whatever state it's in, or in some cases, it's in state court. And for example, in North Carolina, the state court handles it, and Buckner v. City of Asheville is an example of one in which the state court handled the issue. So ultimately, which benefits or payments can be recovered? That relies on a state-by-state review of the statute, what the statute says about what can be recovered, the words that the legislature uses, and I don't think I'm going to shock anybody here when I say legislators are absolutely clueless. They don't even understand work comp subro, and they're writing the laws. So it's not a perfect system, but that's what lawyers are for, that's what you are for, that's what the court system is for, and that's what appeals in the commissions are for. So we'll go through a state-by-state review of what can be recovered as an example of how to look at it, but understand that everything we're going to go through is already included in that chart you have. I'm just going to sort of give you a user's manual on how to operate the chart, how to read the chart and use it when you have to craft an argument to defend why you're including $12,842 in nurse case management fees in your lien, and some lawyer is screaming, "That's bad faith. You can't do that. That's not a medical bill." Well, we'll talk about that. But before we do, we have another poll question. And as we did with the last poll question, there we go. I will read it, and then we'll have like 45 seconds to answer it. Only this time we're going to have a little music with it. So, which of these is not a type of expense payment you may find in a workers' compensation lien? A, nurse case management fees. B, utilization review charges. C, independent medical exam IME charges. Or D, contractor fee for remodeling claims handler's master bathroom. Go. All right, we're done. And before, looks like 81% of you got it right, and 9% of you are going to jail. Good result. So that's that. Now, and let's take a look at a case. I mentioned earlier that sometimes this is litigated, and we are interested in knowing exactly what the charge is and who it benefits. In the case of Cole versus Byrd, this is a litigated example of how these issues are handled. Cole was injured on the job. This is Illinois. He sued the third party, got a nice recovery. Okay, Mr. Cole, despite his serious injury, has some money in the bank. Farmland Mutual, who was the comp carrier, paid comp and intervened seeking to be reimbursed. Plaintiff's counsel, as they often do, challenged $12,577.96 of it, which constituted a payment to a medical rehab coordinator named PRM. They were a consultant. So the issue in this case, and the comp carrier fought it saying we won our $12,000. The issue was whether an expense constitutes a necessary medical or rehabilitative expense under Section 8. And what you have to do is sort of look at what the statute says. The employer shall provide and pay for all the necessary first aid and medical services. And if you look further down, it says all maintenance costs and expenses incidental thereto. So that's where the comp carrier in that case hung its hat. What happened was the trial court ruled that it was not recoverable because it was a case management expense. Just using that term loosely, I guess the court said it was not recoverable. The Court of Appeals said, no, wait a second. This is medical treatment. So even within the hierarchy of the Illinois court system, justices and judges who are experienced cannot decide on whether that payment to PRM constitutes a medical treatment that should be reimbursable to the carrier. So don't be bashful to argue that something is recoverable if you think it is. Just be upfront about it. Supreme Court said, unfortunately, the PRM payment was non-reimbursable as a case management expense. And they looked at Illinois law and they said the act allows reimbursement for necessary medical and rehabilitation services, not the insurer's expenses. Okay, that court decided that this particular cost was an expense. But other states, as we will see, have decided differently. Some insurers' expenses may provide some benefit to an injured employee, but are not reimbursable. So you have to consider the nature of the services provided in the relationship between PRM, which is the consultant here in this case, and the employee. PRM made recommendations to the insurer, not the employee. Okay, that was significant. The carrier, not the employee, controlled PRM's continued services. And so there was a question of fact, the Supreme Court said, and they could draw inferences from witness testimony. So witnesses, here, one particular nurse who was an employee of PRM was put on the stand in this trial and asked the following question: who do you in this relationship have an obligation to answer to, the patient or the insurance company? And the nurse answered, quote, I make recommendations to the insurance company. That's what I'm hired for. Here's another question that was asked by the lawyer. Whose interests are you as a professional? Whose interests do you believe you are obligated to protect in this assignment, the insurance company or the patient? To which she answered, the patient, to see that the person gets the best medical care, ends up being good as a person medically as he or she can be. Next question to the nurse. Would you consider this to be medical treatment or management of the workers' compensation case? She answered, management. And then the question was of the claim on behalf of the insurance company, and she answered, it's still objective. In other words, I make the recommendation to the insurance company that I feel is most appropriate to the case. So these are the sort of questions and queries that we look at when trying to decide whether something is a medical benefit or an unrecoverable expense. And again, states differ. In North Carolina, for example, this is their statute is section 97-10.2. And as we go through these states and discuss these laws, keep in mind that what we're doing for North Carolina here, and then in the next few slides, some other states, and we're going to do Alaska next. This is how we want to craft an argument when someone says, no, that nurse case management fee or that audit bill cost or bill review cost shouldn't be included. Even though it helps keep the premiums low, it helps keep the lien low, which means more money in the pocket of the employee. They're arguing that, oh, we shouldn't be allowed to recover that. So in slam dunk subrogation cases, what I could say is fine, then we won't do it next time. The lien will be 40% higher, and you will owe us a lot more money. So it's a very specious argument to make. But in North Carolina, Section 97-10.2 provides that reimbursement may be had by the employer for all benefits by way of compensation or medical compensation expenses paid, quote unquote, for the employee. So a party claiming a right to reimbursement under this statute, which is you, has to show that the treatment was provided in the form of medical treatment, surgical treatment, hospital treatment, nursing services, and you can read the rest. We have to show that the treatment provided was reasonably required for at least one of three purposes, namely to effect a cure, give relief, or lessen the period of the plaintiff's disability. So you can see this is a barn door big enough to drive a truck through. And that's how we have to approach these cases when we argue in favor of recovering some of these payments. For example, in Alaska, Section 2330.015 provides that the carrier is entitled to reimbursement of, well, what's this? The expenses incurred by the employer with respect to the action or compromise, including a reasonable attorney's fee determined by the board. The cost of all benefits actually furnished by the employer. All amounts paid as compensation and second injury fund, and if the employer is self-insured, all service fees paid under 2305.067. So what does that mean? Now we have to go look at 2305.067. And in the statute, for example, medical care is defined to include physician's fees, nurses' charges, hospital services, transportation charges, etc. The administrative code in Alaska defines a claim for workers' compensation benefits as including compensation, attorney's fees, cost, interest, reemployment, or rehabilitation benefits, rehabilitation specialist provider fees. Now, if the case that we talked about earlier, remember where the nurse was being cross-examined on the stand, if this code had been in place there, this reg, I don't think they would have won that case. I think the Supreme Court would have said, no, it's recoverable. So arguably, each of these elements could therefore be considered included within the definition of benefits. In Arkansas, this is a great example of legal archaeology where you have to look at the statute and determine what's compensation. That's what we're entitled to recover, work comp carrier, only compensation. Well, what does that mean? Not medical? compensation, you mean just indemnity payments? No, compensation. What is that? Well, the statute, another Arkansas statute says that it's defined as the money allowance payable to the employee, to his or her dependents, and includes allowances provided for in 11.9509. Now we have to go there. So section 11.5909 provides for payment of authorized medical, hospital, other services and treatment furnished under 11.9508. So the Sherlock Holmes in us now has to go there. And you can see, you can follow it down, and somewhere in this slide is the ammunition you need to recover some of the nurse case management costs or other fees that are paid in an Arkansas work comp lien, a lien paid under Arkansas law. And that's how we craft these in states that have no clear answer, and many of them don't. Some of them do. For example, in California, the employer may recover the total amount of compensation, and California nicely defines compensation to include all the things that you see there. And as you can see, it includes nurse case manager expenses, nurse statute, medical legal expenses, vocational rehab expenses, etc. Interest, cost of utilization review arguably can be recoverable because it's now mandated by the California Labor Code, even though it may not be a benefit or payment. So you can see that these are all tools, and all of this, by the way, is included in the chart that you have as a handout. These are all tools which you can use to argue in favor of recovering an element of the lien. This is what Emily does all day. I'm not sure if it's all day, but she has to craft these arguments. Our lawyers have to craft arguments to say, no, this $12,000 is included, that $23,000 is included. You're not going to whittle down our lien and then take fees off the top of it for having successfully whittled it down. So these are all arguments that we can use. Florida, for example, is pretty clear that the carrier's subrogation rights do not extend to the payment of vocab benefits, attorney's fees, or claims expenses such as investigation of the use of experts. That would probably include IMEs. So some of these things, it all depends on the state. In Illinois, case management fees and expenditures are unrecoverable. And of course, the Cole versus Byrd case is the one we went through earlier, where the nurse was being cross-examined on the stand. Medical rehabilitation coordinator services are not recoverable, although the Act does authorize reimbursement for necessary medical and rehab services, but not for an insurer's expenses, even though the insurer's expenses may in some way provide a benefit to an injured employee. So somebody made the argument in Illinois that we make in other states, and the court said, nah, we think that's an expense. And now let's go all the way back to slide 1, where I talked about the history of work comp. That's why this is important, and I promise you that the justices who ruled in that case forgot all about the grand societal bargain that is work comp. Otherwise, they should err on the side of allowing the employers to recover because they're not at fault. Now, in Michigan, they specifically held that nurse case management fees can be reimbursable, and there's a case there. Now, this wasn't a case in state court. This is a state where it has to go through the commission, and there's an administrative ruling there. And the court said, although the Act makes no specific references to case management services, drum roll, most states don't. Michigan believes that those services, if reasonable and needed, are contemplated in the types of services provided under Section 315. So they're routinely paid and constitute a benefit and can be recovered. All right? I wish more states were clearer about some of these things. In New Mexico, a lien is described as including payments by the employer to or on behalf of the worker for compensation or barn door any other benefits to which the worker was entitled under the Act. So there's a lot of room for you to negotiate there. I'm sorry, claims adjuster, you can't include that $12,000 fee. No, we can, because Section 52517 says we can. And they will have nothing. They won't cite you a case. They won't cite you precedent because there isn't any. It's a matter of advocacy. And as claims handlers, we have to be advocates as well. South Carolina, same thing. You're allowed to recover other expenses paid or to be paid, and that's significant. So nurse case management fees would arguably fall under other expenses. To me, that seems logical. In Virginia, nurse case manager charges case management services, IME expenses, vocab, rehab charges, attorney's fees, costs, copying charges, private investigator charges cannot be recovered. And here we have a case, another one in the commission, not in state court. In fact, there's two decisions which indicate that that's the case. In Washington, similarly, we have a decision there which dealt with their statute 5124060. The department, because they have the state-run system there, the department and or self-insurer shall be paid the balance of the recovery made, but only to the extent necessary to reimburse the department. Again, you can insert work comp carrier there for compensation and benefits paid. So what does that mean? In this particular matter, administrative matter, the issue is whether the costs of medical examinations are reimbursable, and the commission held, the hearing examiner or the panel held that the cost of independent medical examinations not requested by the employee was an administrative expense and not reimbursable because the benefit to the employee was incidental. Now, that's that judge's opinion. But, it all depends. And, again, here we're going to be making our own arguments. So we get to the last poll question. A claims handler, subrogation professional should A, provide detailed payment logs, and by that I mean provide to the claims counsel, defense counsel, whoever's interested. B, hide nothing. C, be completely transparent. Or D, all of the above. Let's take 45 seconds and answer that one. All right. Let's see what we got for results. 96%, all of the above. Excellent. That's a good result. So let's move on. At this point, I just want to give you an example of some arguments that should be made in favor of recovering nurse case management fees, and I'm going to let Emily do that because that's what she does for a living.
Thanks. And we spoke about nurse case management and utilization review in slide 7, but to reiterate, nurse case management is coordinating the medical care to get the employee back to work. And the nurses, again, are a great hub for information. And why it's so great is it cuts down on any review and re-review of medical providers or reports of an employee's condition and progress. And essentially, there's just no recreating the wheel. It allows someone, a nurse that knows the medical field and what appointments might need to be made or how to write a report on findings, do it in an efficient way, as opposed to having a workers' comp insurer who isn't as educated or trained or licensed to complete the process, and that could just delay any process. And the utilization review is, again, the review of medical services provided to the employee to make sure it's a medical necessity and appropriate for the injury. And we're just not understanding why this is so questionable, since the process essentially saves all parties money. It doesn't necessarily benefit the employee, but I think one of the benefits that it does have is, well, especially with nurse case managers, is there's a constant throughout the whole process for them. They can ask questions or confide in them and also know that there's a nurse that's going to be acting in their best interest. So again, it just keeps workers' comp lien or the amount that has to be reimbursed to an absolute minimum. And if we can encourage the payment of these amounts by allowing it, it'll assist in holding down the workers' comp insurance premiums. And I think now that we're starting to press on this or argue it more, we can see a big shift in recoverability soon.
Okay, excellent.
Gary?
Now, Yeah, the issue of attorney's fees is also one that, and by the way, this is my 38th year of doing this, and I will tell you that I never had the attorney's fees for paid to the claimant, paid by the claimant to his attorney, not work comp defense fees. So there's a difference. Comp defense fees are not recoverable. That's your expense for not paying the claim, for trying to fight it. Okay, it's going to be pretty hard row to hoe if you're going to try and argue to recover those fees. But the applicant's attorney's fees, yeah, in most cases, those are paid out of the award to the employee. And that's usually the benchmark we make. Sadly, there isn't a lot of hard and fast black and white decisions out there. No cases in every state that say yes you can or no you can't. So here's a couple of examples. New York, the attorney's fee is deducted from the benefits awarded to the injured employee. Well, then that's a benefit paid to the employee who just so happened to have an attorney. Sometimes they don't, and so all of it would be recoverable. So to not allow recovery of it just because the injured employee hired an attorney wouldn't make any sense. In Texas, the attorney's fees are determined by time and expense, and the carrier is ordered by the division to deduct the fee amount from the employee's benefits and pay it over up to 25%. District of Columbia describes payments that are reimbursable and includes, quote, the expenses incurred by him in respect to such proceedings or compromise, including a reasonable attorney's fee is determined by the mayor because it's a city, of course, or the district. In Florida, subrogation rights do not extend to attorney's fees. It's going to depend on the state, so another important issue that Emily is going to address briefly here is the catastrophic and complex case outcome-based contractors, which is sort of a lightning rod now, and we're seeing it a lot more frequently. Emily?
Yeah, these catastrophic claims, the insurer might hire a case management company to handle the steps outlined above. And some of these companies are Paradigm or Carisk, and then so many more that I might not even be aware of. But these companies will enter into a contract price that will include paying the medicals. And this contract could be for only a portion of the claim, maybe in the beginning when the most care or coordination is needed, or for the whole life of the claim. And entering into these contracts means that workers' comp is gambling, or the insurers are gambling that the contract price is equal to or less than the amount of the medical expenses that will be incurred. So if it pays more than the contract price, it'll obviously lose money on the deal, but if it pays less, it'll make a profit. And the case management company sets its contract price after assessing what medical or rehab services will likely be needed and then adds in their profit margin. The company's assessment requires an estimation of what type of treatment would be necessary, how long treatment might take, and then the possibility of complications. If the patient's medical and rehab services end up costing more than the contract price, then that company absorbs the extra cost. And then there's two payment amounts to be concerned about when it comes to using these companies: is the amount paid by the case management company to the healthcare providers and the amount paid by the workers' comp carrier to the case management company. And the concern about this is just making sure we have payment listings for both the insurer and the case management company. If we have an insurer payment listing with payments to the case management company, we would also need to get a payment listing from the case management company to show what medicals they paid. We can't necessarily prove a subrogation interest by showing we made payments to the case management company if we can't also prove what the case management company made payments for. Because for all we know, they might just think it's the administrative costs to handling those. And so the use of case management companies is still one of those gray areas we have very little precedent on. And although the case management company does assist in keeping the lien low, in most cases, the cost of the case management is usually unrecoverable, and the recovery is limited to the actual medical expenses that they pay.
Okay, excellent. In the fashion of wrapping up here, we've come up with some rules to live by. As I said when we started the webinar, this is kind of like the movie that starts off with a bang and then kind of ends with a flutter. We don't have answers for you. You can't have a chart that says New Mexico, yes, nurse case management, no, bill review, audit fees. Yes, attorney's fees. And it's astonishing to me that we can be in that situation, but we are. So in order to recover the maximum amount of your lien and to do so in good faith, here's some rules to live by. Number one, provide detailed payment logs outlining the date, amount, payee, and purpose for each payment. That is one of the cleanest ways of making sure that nobody is confused. If you just give them a number or just payment numbers or payment amounts without any additional information, there is the chance that you could inadvertently, because we're all busy, be including something that perhaps shouldn't be included in there, and that's where the trouble starts. Trial lawyers are looking for anything and everything. I don't know if you saw what's happening in Washington lately, but they're finding all kinds of reasons to sue for bad faith. It's where the money is. So we have to be diligent, but we have to aggressively subrogate our work comp claims because of the history we talked about, because our insureds need that risk modifier being held down. So hide nothing. Be completely transparent. Always invite questions as to lien totals and amounts, and be prepared to answer those questions. Defend your reasons for including certain payments in the lien, and that is the thrust of this webinar, is to give you some ammunition and some bullet points and some arguments for making that defense. Be sure to scrub reserves from your lien information. We all know what reserves are. We're running out of time, so I won't go much into it, but that's information internally. That plaintiff's counsel employee has no business knowing what your reserves are, especially in an unsettled case or claim. So you can scrub that. And lastly, again, to be effective at this, follow the words of Mark Twain. Whatever you say it with conviction. Of all the webinars that we give, I'm willing to wager something that you guys have more questions on this one, or perhaps don't even know what the questions are because there weren't a lot of answers provided. What we provided, I think, was a system, a procedure, a technique for attacking or defending against attacks on our work comp liens. So with that, we thank you for attending. It looks like, I'm looking, Jamie, we've got some questions here, and I'll grab a couple of them here real quick. Betty and Charlotte writes, what about things like allocated versus paid versus incurred? And I'm assuming you're referring to whether or not that information should be presented. Just make sure you understand what they mean. Allocated, can mean future reserves. Included paid amount obviously means what it says. Yeah, I would include the paid amounts. And incurred. Sometimes companies use different vernacular for some of these things. Just understand what it is you're providing and make sure that it doesn't include unrecoverable expenses, or if it does, at least make sure they know that up front and give an argument for it. We're recovering nurse case management fees here because, and then, everything we said in this whole webinar. Okay, Todd in Seattle. If the lien goes up after a mediation, what do you do? Okay, I think this is a great question. A little bit off topic, but a great question nonetheless, because you could have payments that are pending, that are made after a settlement, could be in mediation, could be just in correspondence with a third party. But make sure that when you give someone a lien in a case that is open and pending, that you say, this is our lien today at 10:53 a.m. on Thursday, October 3rd. Tomorrow it could go up. In fact, it could go up this afternoon. So if you aren't going to pay us right now, you better well check with us when this settlement is funded, or the lien is going to go up and you're not going to have enough money to go around. So I see some other questions here. We have emails for all of those people who asked questions, and we will certainly get to each and every one of those. On behalf of Emily and I, and Jamie, our moderator, thank you for attending. You should have that handout, which should give you a lot of information, but you have our contact information. Feel free to ask us questions at any time. That's what we're here for. Thank you again. We appreciate your attending.